How was lunch? Excellent. Yeah. If you don't think it's excellent, we'll give you some of the dog food they used to, that recruits used to have to eat, and you'll really appreciate it. Was it already turned on? Jason, I have it in the small of my back, so it's on. Okay. So this is kind of cool. They're thinking if they, tape some of this stuff, they might be able to export it as training to places around the state, which I think is cool. So Jason and I are going to get together and make sure I export the scenarios and the handouts and stuff on a file with it. And your discussion is being memorialized, so all your erudite comments are going to impress law enforcement officers from all around the state. Now that I think of that, I probably shouldn't be bad-mouthing the brass so much. Except I've trained most of them, so they know I'm a crazy dame, so they don't take any of it seriously. Okay, scenario 3. All right, what do you think? Did you need more time to discuss it, or are we good to go? Good to go. Somebody tell me what they think. What do you think, Freeball?
Ma'am, this recruit thinks that she will prevail. Basically, she was trying to do the right thing in identifying that there was a discrepancy with affidavit.
Well, do you see anywhere in the analysis on the PowerPoint in front of you where do the right thing cuts the mustard?
No.
Okay, learn to apply the legal test in the language of the legal test.
Yes, ma'am.
Go ahead.
So, regarding this, it's not public concern.
You don't think it's public concern?
No.
Okay. So what are you? So you've changed your mind. She won't prevail, or he won't prevail.
Yes, I don't know what I said. When it comes to, I think she should be just found liable or sued within the department, not by the government.
Will she be out? He or she be out of a job, or will you use your words?
I think that she would be out of the job.
Okay.
And it's really hard for me to go. I see it both ways. So
Well, argue either way using the test. Because, hey, if poor Cynthia Moreno, I mean, wouldn't you like to help out Cynthia Moreno and her family? Unfortunately, we have to apply the law. And so you apply the law, and it's right up there, and tell me why she will or will not, or he will or will not prevail.
she will prevail. Let me start over. She will prevail because I'm going to go with it is a public concern because it has to do with OCS. When it comes to OCS, I think the general public finds that a very big public concern.
And affidavits.
Affidavit, yes.
That are sworn statements that courts have to rely on. Okay, so you got one. Then
Not as a private citizen, though.
well,
Capacity under OCS and under a job.
okay, so you want to change? I'm going for your final answer. What is your is that your final answer? She won't.
She will not.
You think she's got one? But she doesn't have 2, and the test says you got to have 1 and 2 before we even get to 3.
Correct.
Okay. Anybody differ? I saw your hand right at the same time.
Alaska's whistleblower statute.
I'll address that. I used to have whistleblower statute slides, and we spent a lot of time on whistleblower, and I felt that got us off track from internet, you know, and rights. But I will answer that question. I have a note to answer that. But I want to answer this question first because the whistleblower statute is also based on reports of matters of public concern. So, and it doesn't require the private citizen part, though. That's the difference. First Amendment. Whistleblower protects you as a public employee reporting. Yeah. So we'll get to whether whistleblower. So who thinks she wins? Or who thinks the fired employee gets their job back? Do you think they'll get their job back?
Just under one stipulation. In here, I guess I was just assuming the whole time that this was during her duty or during whoever's working while they're on the job.
Mm-hmm.
But I could, after reading through it again, I could see a lot of this taking place on off hours. And
Assume it wasn't during off hours.
Oh, then.
Okay. Yes.
Definitely don't think that the First Amendment suing the department for violation of First Amendment rights for something you did while at work is the necessary.
Well, what she's saying, she's not suing. Well, what she's saying is this is constitutionally protected speech. So you can't fire me for First Amendment constitutionally.
Right. Disagree with that.
Okay.
I don't think that she should be suing for that reason, but is there an ethical wrong there? Definitely.
Well, that's what he's asking whistleblower.
Right.
So we'll get to that.
Yes.
Okay, we'll get to whistleblower. Well, this was a real case. Out of California. Again, the only fact I changed is it wasn't a cop, and it was an assistant DA again. And I love this because if lawyers don't understand, we got 2 cases where a lawyer loses their job because they don't know what's protected speech and not in this government employer-employee relationship that Spears distinguished for us. And we got lawyers that can't figure this out, Spears, and they're getting their butts fired because they don't know what they can do and not do. So the case was, Garcetti was the Los Angeles district attorney at the time. And he was the one who appealed the lower court's ruling in favor of the assistant DA. So it goes up to the Supreme Court. And here's what the Supreme Court says about the facts. Would you read that for me, please? Recruit Eccleston.
Speech by a public employee, even if on a matter of public concern, is not protected if the employee is acting in her official capacity or duty.
So this, see, we're working down the chain. We've discussed what are matters of public concern, what are not, and now we're on the second thing. And the court found this speech was not made in the capacity of a private citizen. And here's what the court said: restricting speech arising from a public employee's job responsibilities doesn't infringe on the employee's private citizen First Amendment rights. It simply reflects the employer's control over the employee, which they've contracted for. And the Supreme Court didn't say this, but I translated that. An employer does not have to pay an employee for insubordination, for going outside the chain of command. They don't have to pay them to go out, for that. And in fact, they can be disciplined for going outside the established chain of command. Did you have a question before I answer yours and Rubio's question?
No,
ma'am. Okay. So, let me just finish up with what the court said, and because this leads us right into my little gifted kids that I am pedaling as fast as I can to catch up with. I'm trying to catch up with you. Think about that. Don't you think I should get a wristband for that?
Yes, ma'am. Yes, ma'am.
No, I have extras. I'm the candy man. See, I don't even politically correct the candy man. I got pockets full of goodies. Wristbands, marbles, stickers. Okay, so the court went on to say this. Would you read this, Recruit Alexander?
While even honorable speech may have no First Amendment protection, whistleblower statutes and labor codes can play a significant role to protect employees who dare to expose government misconduct.
I deleted the slide with the Alaska whistleblower statute. It's long, it's complicated, even when I try to, I will just tell you, I don't think this is protected by Alaska whistleblower statute. Look it up, AS 39 something. Just Google Alaska whistleblower if you want to make an argument with me. Bring it on, I love it. I'll learn something. But I have looked at it, I have examined it. And Alaska's whistleblower statute also uses the term public concern. Then they statutorily list what counts as matters of public concern. They don't leave it open to interpretation like the Supreme Court where we're figuring out, well, do they really care about your morale or is it just public? They specifically list the things that qualify as a matter of public concern for Alaska's whistleblower statute, and I don't think this fits any one of those things. I don't think it's the only one that you could even argue is mismanagement or abuse of office, trust, whatever the language was. And here's how this plays out to me and why I don't think it's mismanagement or abuse. If I go back to the facts of this case, defense attorney says, I think the search, I'm filing a motion, I think the search warrant is based on inaccuracies. Is that lying? Oh, your reports and your testimony are going to end up with inaccuracies in them. Does that make you a perjurer? Evil? No. Do you know what the caseload is for CPS workers? Yeah, right, Torgerson. That's right. So it's based on inaccuracies. So far, we don't have any evidence somebody has intentionally perjured or lied. That's a different matter. That's a different matter. You learn this from the defense attorney. You check it down. You're not satisfied with the explanations. You take that up the chain of command, which is what you're supposed to do, right? You get fully heard. Your memorandum gets read. Your concerns are heard at a meeting. Your concerns in your memorandum are discussed at the meeting, and people don't agree with you. Then it's taken to the prosecutor. That's me. Who's trained in the law? Who's trained in the law to know whether these inaccuracies would require dismissing the case? Right. I'm made fully aware of all of this, and I don't agree with you that whatever you found or the defense attorney is alleging requires dismissing the case. I don't know enough of the details. I don't know if there's enough evidence without the affidavit. If we didn't even have this social worker, we could make this case. I don't know what reasons were, but I'm the one who's charged with that. And I say, I don't agree with you. Yeah, I've heard it all. Your superiors have heard it all. I've heard it all. I don't agree that the case needs to be dismissed. And then the judge hears it all. Because the motion to suppress goes in front of the judge. It all comes out. The prosecutor, I know this is going to come out. That's the basis of the motion to dismiss or suppress. It's going to get a full hearing in court. And the judge agrees with me. Nothing's been hidden. It's all out there. What this ADA or ICASIT police officer decided to do when nobody agreed with them is to go outside of the chain of command and without approval contact the defense attorney and offer his services or her services to the defense because the officer didn't agree with a prosecutor and ultimately the judge. And I don't think that would be protected by the whistleblower statute, because I don't think this is mismanagement, abuse. It's people disagreeing on what needs to happen based on these accuracies, and everybody thinking one way except this officer who decides to maverick. Yes.
Just a quick question. As far as if you happen to know that maybe this is a really integral part of the case, or even the person's innocence was, or basically it's a lie that it's built upon or something, and so it's possibly going to incriminate somebody who really is not deserving of that, yet you go through the chain of command and that all goes about, would you recommend not doing that then still, or?
Make your case. If you can't persuade the prosecutor, and understand, if anything's being hidden, that's a total different ballgame. If inaccuracies are being hidden or redacted, if anything's being hidden, that's totally different. I've gone to my boss and said, I don't think we have proof beyond a reasonable doubt. I don't think this case should be taken to trial. I think there's a reasonable doubt. I have a reasonable doubt. When I come back in November, you'll see the role of the prosecution. My code of professional responsibility says that a prosecutor should not be forced to take a case that they have a reasonable doubt about. Now, why do you think that is?
You don't believe in it, how's it going to work?
How am I going to be an effective advocate? So it'll get reassigned. Nobody's hiding the ball. We're not talking about hiding any evidence. So if you're absent hiding any evidence, make your case. Try to persuade your boss. Try to persuade the prosecutor. Understand, it's all going to get heard, and the judge agreed with everybody else. Whatever, maybe they threw out the affidavit. I don't know. Maybe they decided, look, there's no evidence the OCS worker intentionally lied. You can cross-examine the OCS worker at trial on these inaccuracies, and the jury can decide whether they think that affects the credibility on all the other stuff that was accurate. I don't know all the machinations, but in a situation like this where there is no abuse, mismanagement of funds, corrupt, hiding stuff, yeah. I've been in that position. I've had to make arguments. Sometimes I've lost them. And I've had to try the case because I said, yeah, I can try the case and I can be very effective, but, I think it's a dog of a case, but, I defer to your greater experience, boss, and you won't have a better advocate in the court. I'll squeeze everything I can out of the evidence we got because I believe he's guilty. I just don't think we have enough proof, that kind of stuff. So, so that's how I think you should do it. And I've had officers make cases to me about why I should take something that I had declined and change my mind. They've been an advocate for their case and said, well, I think you can counter that with this, or what about this? Oh, I hadn't thought about that. What about the fact that he said, give me a break, I just got out on parole. And I tell him the jury can't hear he just got out on parole in terms of consciousness of guilt. The jury can't hear that. I'll explain when I come back in November. They can't hear about a prior criminal history of a defendant. And he said, yeah, but can't you argue to the jury that when he asked me to give him a break, that's consciousness of guilt? Give him a break from what? Innocent people don't say, hey, give me a break. They say, I didn't do it. You got the wrong person. And I hadn't thought of that. And it was a very good argument. So we went to trial, got a conviction. Good question. You're going to have to be you're going to have to be arguing these things, but understand as long as nobody's engaging in unethical, hide-the-ball kind of stuff, your difference of opinion doesn't let you go out of the chain of command and become a maverick. Well, you can, but understand that you may lose your job. And the court will uphold that. Okay. So we've gone through public concern. We've gone through private citizen. What about if we have a case where we have public concern and private citizen? Let's take a look at the case where the court had to go to number 3, the Balancing Act. Nixon versus City of Houston. Nixon was an officer with the Houston Police Department. He wrote an opinion column for the newspaper in his off-duty time. That's a dispositive fact. Off-duty time. He identified himself as a police officer in the column, and he wrote about police activities, police policies, and his own duties as a Houston police officer. Okay, off-duty, those 3 things: police policies, police activities, his duties of a police officer. Do you think those are matters of public concern? Okay. A citizen complained about one of his columns to the department. Nixon did not have prior authorization to write this column, so the chief ordered an investigation into the citizen's complaint because the chief didn't even talk about not part of his official duties or capacity. The chief didn't even know he was doing it. So it was as a private citizen. When they investigated these different columns he had written, they found, in addition to writing about police activities, policies, and his own duties, he made offensive, disparaging statements about minorities, women, and the homeless, which covers just about anybody other than him, a white guy. I guess he didn't trash old people unless they were homeless or a minority or a woman. Okay. He was fired, and he sued, claiming it was in retaliation for protected speech. Do we have a public concern? Is number 1 met? Is number 2 met? Yes. So then, I'm not going to flip back. Look at your handout. Then what does the court do if we have 1 and 2? I'm going to smack you. Did you drink any coffee? What?
I had mouthwash right after. Wasn't able to drink coffee.
Did you drink any coffee? Did you intake any caffeine? Here, I'm pushing drugs.
Yes.
Go stand in the back of the room. Take your stuff, stand in the back of the room. The one thing I learned about super soakers, see, I know if you're falling asleep, you're supposed to stand up in the back of the room, right? Okay. And I don't do the inchworm thing and stuff like that, but I do engage. One of the corporal's kids has a super soaker. So I decided with somebody with Hall's challenges that I'm seeing like this, is I'm going to stash a super soaker here. And I used it, and it was so much fun. The problem was all the collateral damage. I got my target really, really good, but I got a bunch of collateral damage and papers.
Collateral damage to see that.
They didn't either. In fact, there's a picture somewhere where we're all soaking wet, standing there with me in the center holding my super soaker. Okay. Well, come back and sit down because they don't mind the collateral damage. So I'll get a super soaker lined up and we'll have some fun. Okay. All right. So what's the third step in the test? Yes, recruit Alexander.
You have to still weigh the speaker's interest against the substantial interest in law enforcement agencies' orderly operation.
Not just orderly operation, but trust of the community, cooperation of the community, faith of the community against the officer's First Amendment protected right to express whatever his opinions about minorities, homeless, and women. So, what do you think the court in Nixon, how do you think they came down? Anybody think they came down in the officer's favor? It's Texas. No, they balanced. The police department's interest in maintaining positive working relationships in the community against Nixon's interest in speech. And they held for the department. And, you know, as every other officer in that department, I'm thinking, thanks, man. Thanks for putting a target on our back when we go into these neighborhoods and we're dealing with these people and we're getting sued civilly and we have to do the civil in addition to the criminal, and we need people's help and cooperation because to help us not be so endangered, but to make cases. Thanks a lot. I hope they don't think we're all like you. Yes,
Without taking
Kid Johnson. Yeah.
Without taking issue number 3 into consideration, I mean, I understand that maybe some of the issues you raised were legitimate public concerns, but it seems disparaging comments about women, minorities, and homeless people couldn't possibly.
Those aren't matters of public concern.
Right. So even if you didn't have number 3, could he still be subject to disciplinary action because at least part of his statements were inappropriate and not meeting criteria?
But he's writing about matters of what the court said is he is writing about matters of public concern. They didn't parse out the speech. Within the matters of public concern, you know, he's being offensive and derogatory. But the fact is, he is writing about matters of public concern. That's how they did it.
You kind of take the legs out of his case, even if he didn't meet number 1 in the public concern thing. You're not strengthening his case at all, correct? Because now you're just saying he's not protected under.
If it wasn't, yeah, if it was, I mean, if it wasn't a matter of public concern, we don't get to the balancing. But the court gave him that and didn't separate, well, those particular statements aren't matters of public concern. We grant that your speech was, you were writing about matters of public concern. And within that context, because you were writing about matters of public concern and as a private citizen, you have a protected First Amendment right to express your opinions about these people you encounter, however offensive it might be. You meet the test. Not everybody expresses matters of public concerns in a way we all find acceptable. People trashing the police are addressing matters of public concern, right? So how they do it, as long as they're public concern and citizen, how they express it is protected. Okay. Can you imagine? I know it's a huge stretch and a leap, but your minds are parachutes. Your hearts and minds are parachutes, right? Where's Burkett? You guys covering them? Okay, okay. Oh, did you notice we didn't have a pretest? When we conclude this instruction, at the very conclusion, we're not waiting for Saturday, you're going to have a test. And it's going to be a big one. It can be dispositive of whether or not you leave the academy in good standing. Got everybody's attention? Good. Good. Okay. All right. In the wildest stretch of your imagination, can you imagine ever having with you while you are on duty your personal cell phone? Who can imagine that? I got to tell you, all the brass have theirs with them because they're very important people. They have to be able to take the call from the White House. Okay, so the only one is Del Botton. You would never have your personal cell phone with you. Okay.
Wait, it's only 8 hours, 9, 10, 12. I'll check in, but I'm not going to have my personal.
Okay.
I know where you're going with that.
All right. But it's obvious that the vast majority of people in law enforcement, including the brass, don't think it's unreasonable for you to have your personal cell phone with you on duty. Are you already with an agency? Okay. Do any of your agencies forbid you to have your personal cell phone on duty? Right.
They won't tell us to have it with us.
What?
I think, aren't we kind of like required to have it with us? Yeah.
Some agencies require it because it's a cheap way for them to have technology at their disposal. They don't have to pay for it, right? I mean, some of them encourage you as long as you'll let them, you know, whatever, contact you, or they know, you know, officer that's not worrying about his family is a better performing officer, whatever the reasons are. I haven't seen any policies that forbid you to. I've seen lots encouraging you, and the rest where there's no policy, who isn't connected to their cell phone other than Del Patton? Yeah, we're going to all end up with cauliflower ears. Question before we proceed?
Just a comment on that. DPS gives us a stipend for our personal cell
How about that?
or smartphone.
That's cheaper than them having to buy phones for each and every one of you. How about that? I know, that's the way it is across the nation. So, I'm going to read you a scenario, and then we're going to work. You may be able to hear this scenario and say, that would never happen to me, right? It's like the people that say, well, that victim was engaged in high-risk behavior. That would never happen to me because I would never go drinking with a stranger and then go home with them. And I always worried about those people on rape trials because it's like, I'm sorry, that behavior on the part of the victim is not an affirmative defense. Stupid victim is not an affirmative defense to a crime against the person of sexual assault. So, but here's taken from the headlines. Imagine yourself in this scenario. You, another trooper, and 2 deputy U.S. Marshals go to Carlos Bowles' home to serve a felony arrest warrant on him. He opens fire. I'm not going to be taken. He opens fire. You and both marshals are wounded. One of the marshals later dies from his wounds. Bowles is killed in the shootout. So we got 2 wounded officers, and we've got a fallen brother lost from the family. A photo of Bowles' bullet-riddled body lying in a pool of blood ends up circulating around the city. A college student who received it reported it to AST headquarters. I've just plugged you and AST in. This is a real case from the headlines in Maryland, and it was 2 deputy U.S. Marshals and a local police officer. Reported it to AST headquarters. It also made its way to other citizens who had upset. A TV news station, which only voluntarily refused to publish it, but reported it may have circulated on Facebook, and it ended up being sent to Bowles' family. Alaska DPS and the Marshal's Office initiate an internal investigation to determine who took that photo and how did it get leaked outside of the agency. As part of that investigation, they demand a history of the picture messages from your cell phone, the other trooper's cell phone, the 2 deputy marshals, and other later responding officers on threat of dismissal. You and all the other officers seek an injunction against the department in federal court. You assert the cell phones were not department issued, they were personal. You say your phone doesn't even belong to you, it's your spouse's. Another officer says his phone belongs to his mother. You and the other troopers are represented by your union. The family members who allegedly own 2 of the phones are represented by the ACLU. Both claim the department's demand violates yours and their 4th Amendment right against unreasonable searches and seizures. And this is now in federal court. Explain which side you think will prevail and why.
Ma'am, I believe that as the officer, the employer, if they're giving you a stipend or supplying you money to pay for your bill for your phone, then it is actually still part of the department, so they have every right to actually take your phone.
Let's say they're not.
They're not supplying
Don't
you any?
see, this is what always happens in law school. And my professors always said, well, yes, if you change the facts, we get a different result. These facts are personal cell phones. One isn't even the officer's personal cell phone. Belongs to the wife. Another belongs to his mother. There's no stipend, no issue. No issued phone, nothing. Recruit Lopez.
Is there a scope of the search within the cell phones? Did they say photo